If you have an interest in a family trust, it's really important to review the deed and any amending deeds that establish the trust. This way, you'll be aware of the terms that govern your trust before you go ahead and make your will. You need to consider the following issues when making your will. Trust assets are not governed by a person's will. Trust assets can't be dealt with in a person's will and can't be managed under a person's power of attorney either. They can only be dealt with by the trustee and only in accordance with the terms set out in the trust deed. So it's important to make sure that, on the death or incapacity of the trustee, or on the death of a shareholder or director of the trustee company, the position of the trustee or control of the trustee company will pass to the right person. Pursuant to the terms of the trust, there may be a person who has the right to replace the trustee with someone else of their choosing. This person is often referred to as an appointor or principal of the trust, and they're really the person with ultimate controlling power in relation to the trust. The trust terms will often enable the appointer to choose a replacement appointer on their death or incapacity, either in their will or in a deed. So, it is therefore important to review the terms of the trust to see if and how a replacement can be appointed, and to make sure that the appropriate provisions are included in the will of the current controller. It is not uncommon for a person to loan monies to a trust, or for trust distributions to be recorded as monies owed to a person. If a person who is owed money by the trust dies, unless the terms of the loan provide otherwise, the deceased's executor may be obliged to require the repayment of the loan, so that the funds paid can be distributed to the beneficiaries. This could result in the forced sale or distribution of trust assets, which may trigger capital gains tax or other losses. To avoid this, you can ensure the loan terms do not automatically allow the executor to require repayment, and/or include appropriate provisions in the will of the person authorizing the executor not to demand immediate payment or gift the right to repayment to someone who will not require immediate payment. For any assistance, please contact MJM Lawyers, your trusted New South Wales wills and estate lawyers, led by our founder Michaela Money, who became a solicitor in 1998 and has been an accredited specialist in wills and estates since 2009. Visit www.mjmlawyers.com.au to book an appointment or call +61 0280 3139. With a wealth of experience, Michaela Money and the team are here to guide you with confidence. Liability limited by a scheme approved under professional standards legislation. Disclaimer. This post contains information of a general nature only and is not intended to be used as advice in relation to a specific matter. Although every care has been taken in preparing the document, it may not be accurate or complete, particularly in the context of specific circumstances. MJM Lawyers disclaims responsibility for any errors or omissions.